Good afternoon, everybody. My name is Doug Johnson. I'm one of the juvenile court judges here in Douglas County. I know many of you. Some I hope to get to know you. If we don't have time today, I think we will in the course of this project. But some years ago, a conversation occurred where I was speaking and talking about the future direction possibly of juvenile court or domestic relations. And I said, if we were bold and we had vision, we'd take a look at what we're doing because we're so split up. One family can have multiple touches in juvenile court, county court, district court, and I kind of call that a circus maximus. And I knew that there were models through the country of excellence, but they're fitting the locale and what the mission would be. So the Supreme Court gave the blessing to study this issue through the Supreme Court Commission on Children in the Court. So I co-chair a subcommittee for this with Monica Kruger, a practitioner who's been in all the courts, as you know. And it took some time to do this because we had to work to get some funding and planning to do it correctly. And so our charge is to investigate this, to study what we do, dialogue with stakeholders, with a focus on how we better serve children and families. And I'm not saying I have the answer. We're on the path asking questions and learning. And then our task is, after all of this is analyzed and chewed on and discussed and so forth, is to present some proposals to the Supreme Court. So I don't know where this may or may not go, but the adventure has begun. And so we've also partnered with the National Council of Juvenile and Family Court Judges, but one of the leading experts in all of this is Professor Barbara Pfaff, and she is an associate professor of law and director of the Center for Children, Family, and the Law and Courts there at the University of Baltimore School of Law. She's written extensively on this. She's trained extensively on this, and we are really graced with her and her team. Gloria Danziger, a senior fellow there, and Diane Nunn, who is a consultant. And we've done some work with the California courts and the like. So we've got experts who are really, really good at this. So we're glad you're here. This is an introduction to understanding the Unified Family Court. Also, I forgot to mention, this is a court improvement look-see, so to speak. So this is not just stick your finger in the air and see which way the wind's blowing. The court is looking, the Supreme Court is looking for systems change that work, that make a difference. And so this is a great opportunity. We're working with Deb Van Dyke Reese, who is the Court Improvement Director, and she was right there. She helped write the grant and is our partner in all of this. So I'd ask you to help me welcome our experts and enjoy this presentation. Please.
Thank you very much. It has been a true pleasure to work with these amazing folks, and I think on behalf of my team, I want to thank Monica Kruger, Deb Van Dyke Reese, Judge Johnson, and this morning, Mary Pat Coe. I'm not sure if Mary Pat's here. There you are, who has been kind enough and gracious enough to shepherd us around this, the courthouse. But we started this work in April of 2016. To give you a sense of how this got started, Monica emailed me and had been connected to me by her cousin's husband, who was a former student of mine. So that's how sort of small world kind of connections work. And from there, we have spent the last 2 years communicating as a team. We've had multiple conference calls. Deb was very successful at obtaining a grant from the Sherwood Foundation to fund this work. And we really have enjoyed the process so far and look forward to continuing. I'll say at the beginning, this is, as Gloria calls it, a listening tour. We're not here with answers. We're here to learn about your system, to tell you generally what we know and have learned from other courts, and want to do the best that we can to assist you in doing the best you can for Nebraska's families and children. We know that's why you're all here, and so are we. So without further ado, we'll start the PowerPoint presentation, and there'll be a chance along the way for you to learn more about us and for us to learn who you are in the audience. We really want to know who is represented here. Center for Families, Children, and the Courts, now known as the Sarah and Neil Meyerhoff Center for Families, Children, and the Courts. And this evolved out of work that we have been doing with family justice systems, both in the state of Maryland and really around the country. And the mission of our center is family justice system reform. We look to identify structures and processes to improve families and children's lives. And one of the best ways we think that can happen is through the creation of a unified family court. We have a website, we have a Facebook page, we have a blog, we even have a Twitter account, although I have never tweeted. Some of our younger staff do the tweeting for us. I don't know if you tweeted, Gloria. And we have an email. We have a newsletter that we publish twice a year called the Unified Family Court Connection. I don't know if any of you receive it. It's free, and it's both online and mailed. And we had a sign-up sheet out in the hallway, I believe. Deb, is that where it is? So if you'd like to be on our mailing list, our email list, we would love to invite you to join in our work. So, who are we? I'm going to allow my colleagues to tell you a little bit about their amazing backgrounds with court reform work, family court reform work, and then we'll hear a little bit about you as well. So, first we'll hear from Diane Nunn, who is our consultant from the state of California.
Thank you, Judge Johnson. Thank you, Laura. I started my legal career as a family law practitioner, and as a result of that, did some juvenile law work representing some of the my clients' children, and then went to work at the Los Angeles County Juvenile Court, sitting as a juvenile court referee, magistrate, hearing primarily abuse and neglect cases, but some of the also on the juvenile justice side. And I was there for a few years when I was contacted by the California Administrative Office of the Courts. They had never had an attorney working there who had any type of juvenile law background, and they wondered if I would be interested in coming to work and to focus on policy issues. And I decided, that sounded really interesting. So I went to the Administrative Office of the Courts, and as things changed around the country, as the court improvement money came in from the feds, as Title 40 child support came along, things started evolving. And our former Chief Justice, Ron George, came to me one day, and by that time I was a managing attorney over a lot of different pieces of family and juvenile type cases, and he said, Diane, why don't we establish a center? And although we were a continent apart, in the year 2000, at the California Administrative Office of the Courts, I became the founding director of the Center for Families, Children, and the Courts. And lo and behold, I heard about this other center and this other fantastic individual who was interested, as we were, in looking at how we can better serve children and families in our court systems. And we invited her out to do a presentation very similar to the one that she's doing today. I will tell you, as somebody who worked within the court system for 30 years, that it does work. It really does when you put the focus not on what door a family or a child comes walking through, but what are the issues and how do they relate, and how do we as public servants in all our different roles within the courts help to serve these families. And so I just retired last year from California, but I couldn't stop caring. And so when Barbara asked me to help out on this and do consulting, I joined the team. But I applaud you for your willingness to listen and participate, and hopefully we can work together to come to some great solutions. Thank you.
Good afternoon. My name is Gloria Danziger. I'm, as Barbara mentioned, the Senior Fellow at the Center for Families, Children, and the Courts. I came to this relatively late. I was a newspaper reporter for many years, covering the police beat in Atlantic City, among other places. I always felt, when I was writing about these cases, that the law had an incredibly important role in these families' lives. So I decided to go to law school. I went to law school. And following law school, I went to the American Bar Association, where I served as the staff director for the Standing Committee on Substance Abuse. As part of my charge, I was asked to write a proposal on something called Unified Family Courts, which I had no idea what it was. Nobody I spoke to had any idea what it was. But they told me that Barbara Babb was the authority and the one to go to. So I met with Barbara, she explained it to me, and long story short, we got a $500,000 grant from the Robert Wood Johnson Foundation to develop and implement Unified Family Court pilot projects in 5 jurisdictions around the country. The interesting thing about that grant was that they were very focused at the time on substance abuse and addiction. They saw, as we had presented it, Unified Family Courts being a very powerful vehicle to address the needs of families and children in family court. A lot of work had been done, as you all know, in the criminal justice area, but very little, if anything, had been done in the family justice system. So over the course of about 4 years, we worked in 3 jurisdictions, actually, in Puerto Rico, King County, Seattle, Atlanta, Baltimore, and Washington, D.C. And I'm very happy to say that in all 4 jurisdictions, Washington, D.C. did not want Unified Family Court for many reasons. But in the 4 other jurisdictions, Unified Family Courts are up and running and very much focused on addressing the needs of families and children with addiction problems. Following that, my years at the American Bar Association, I was very lucky to have Barbara recruit me to join her at the center, and for the past 15 years, I have worked side by side with Barbara and had the honor and privilege of continuing this important work in family justice system reform.
Thank you very much. You can see that we have some great expertise and are just, anxious to hear from you and to share what we have learned over many years being in the trenches and doing this work with you. How I came to Unified Family Courts, I was a high school teacher in New Canaan, Connecticut, and I decided I was teaching child development to high school students. It was a very progressive high school. And I decided, maybe I should go back to graduate school. So I went to graduate school and got a master's degree in human development and family studies. I sort of meandered my way here. When I was getting my master's degree, my mentor, who's Dr. Yuri Bronfenbrenner, we'll talk more about him later, said, why don't you go to law school? Because I was very interested in policy, family policy. So I went to law school, and I focused my work in law school on families and children. Did not plan to practice law, but when I graduated from law school, because of certain things that were happening in the government, most of the policy jobs were gone. So I ended up practicing law in upstate New York, and I practiced in a wonderful family court. It was just a great rural family court, but with very caring and committed judges, and just, I thought that was the way family law was practiced. I then moved to Maryland 3 years later, and I started working at the Legal Aid Bureau in Baltimore City, where I was in charge of all of the family law cases and supervised the attorneys who handled those cases, and realized, there's no family court in Maryland. My clients were appearing in several different courts. One court didn't know what the other court was doing or ordering. My clients had to appear several times for related issues on the same matter, the same case. So I suggested, maybe you ought to think about a family court, and that began sort of a decade-long grassroots effort to create a family court in the state of Maryland. You heard from Gloria about how we partnered, and we had the help of the American Bar Association. We did become one of their pilot sites, Baltimore City, and we now have what we call a family division in the state of Maryland, which is functioning essentially as a unified family court. I have practiced in that court. I supervise law students who practice in that court. We teach law students about the work we do. So we're very embedded in this. I do write about it quite a bit as well. If any of you are interested, I'm going to put a plug in here. I am the editor of the Family Court Review, which is a publication of the Association of Family and Conciliation Courts. So if any of you want to submit an article to Family Court Review or you're thinking about it, I'd be happy to talk to you about that as well. So that's basically how all of us came to this work. And we'd like to hear a little bit about, I guess we don't have time for introductions from everybody, but we'd like to hear a little bit about who's here, who's represented. I know that some of the judges in the room. How many are judges? Very good, thank you. How many of you are attorneys? I guess everybody else is an attorney. Court personnel? And is anybody willing to talk about who they represent or the position they hold? We'd love to hear a little bit about some of the people in the audience. Anybody willing to tell us something? Raise your hands at once. Yes, thank you.
Hi, welcome. I'm really thrilled that you're here. My name is Deborah Denny. I am in the State Court Administrator's Office in Lincoln. I'm the Director of the Office of Dispute Resolution, and I've worked in this field for many years. I was also a practitioner in juvenile and family law. We do a lot of ADR, family group conferencing for children and child welfare cases. We mediate parenting cases. We're doing restorative justice and juvenile justice cases. And so the mediation arena in Nebraska has 6 regional mediation centers. There's a conciliation court here in Douglas County for parenting. And so and there's a lot of lawyers who are in the room that are also mediators. And so there's a lot of that ADR practice where we're opening up the table for more people. And so having a unified court just makes a lot of sense. And so Deb and Reese and I have been talking about this for a long time, and I was really excited that Judge Johnson said, hey, let's pull this forward with the Supreme Court Commission. Nebraska did do an evaluation of our parenting act in the custody with the National Center for State Courts about 2 years ago to look at what are some of the indicators and outcomes of our family law, our parenting act law. So I think in Nebraska we've done a lot of things to lay a bedrock to be just really ripe and ready.
And I do want to compliment you on the work that you've done. We've done a lot of reading. We have been sort of inundated, quite honestly. We asked for material, background material, and we got it. And we've been working our way through that, and you really have done amazing work at stepping back, looking at the way various systems are functioning, getting recommendations from the National Center for State Courts, the National Council of Juvenile and Family Court Judges. You really have done amazing work. So I do want to compliment any and all of you who've been involved with that. You've not been just sort of sitting still and letting things happen. You've been very proactive, and I think that's our sense from reading so far what we have read. Anybody else want to just say who you wrote? Yes.
Yeah, we're with CASA, and we're excited to be part of new changes within the juvenile court here. We have been taking a collaborative approach with impact from infancy and then first court also here, and we're just really interested in finding out more information about how we can be involved and work better with families.
Yes, that's a wonderful organization. Diane has some connections with that at the moment, so excellent. Anybody else? One or two more? Yeah.
My name's Jane McNeil, and I'm an attorney that's been working in juvenile court for a long time. And many of us in this room kind of basically do the gamut of parents' attorneys, guardian ad litem for parents. So I think that anything to simplify things for parents, because if we're dealing with them, then there's already a problem. So anything that we can do to simplify and streamline to make things not as confusing for them, I think that we're all in favor of.
Thank you. Anyone else? Yes.
My name is Carly Peterson. I'm the clinical director at Behaving Kids. So we are therapists that often work with foster placements or children that are going through divorce and have to come testify. We also have an adolescent IOP program that we launched. So just kind of wanting to be aware of everything.
Excellent. All right, well, thank you very much, and we hope to get to know some of you. We've seen some of you in action. We've been observing court this morning. We'll be here through Thursday, and you may see us pop in and out of court. It's been enjoyable so far. We really have very positive feedback about our visit. At the moment, right now, I'm going to, hopefully if technology works for us, in 2007, the center partnered with the American Bar Association, and we convened the second of 2 ABA summits on Unified Family Court. The first one was in 1998 in Philadelphia. I don't know if any of you attended that. There were teams invited from every state, and it was a wonderful conversation, and we decided it was time for another. So in 2007, we convened a second summit, which we held in Baltimore. And this is a DVD that we did in preparation for that. It's just an overview of a unified family court, and it also gives you a chance to hear from some judges who have worked in this system.
Judith Hamilton and Candy McCall are strangers with one life-altering thing in common. Neither ever imagined their marriages would end in divorce.
I think it's probably one of the worst things to go through, worst things in the world, worst thing for your kids.
I didn't go into being married with the expectation that I was going to get divorced.
Statistically, about 50% of American couples divorce, Judith and Candy among them. But their journeys to dissolve their marriages took 2 very different legal paths. Judith went through the traditional court system, appearing before 2 masters, 2 judges, and multiple hearings to settle the divorce, resolve custody, support, and visitation.
It's frustrating because there's not one person who is kind of there from the beginning and knows what you're dealing with and knows what you've been through in the past and, you know, what you're facing there at that time. So it can be frustrating. It's like having to tell your story over again from the very beginning.
Candy's case went through a unified family court, and her divorce was resolved through mediation, quickly and, considering the circumstances, relatively painlessly.
Well, this system worked well for us, I thought. I didn't feel bounced around. You know, the location and time and was all clear. It was all pretty structured. There wasn't lots of waiting on any given day. So it all went smoothly.
The American Bar Association has supported the unified family court model since the mid-1990s. Originally, the ABA developed and implemented 5 UFC pilot sites in Puerto Rico, Atlanta, Seattle, Markham, Illinois, and Baltimore, Maryland. Baltimore City's Family Division pilot project became permanent in 1998. Here, the intent is to try and decrease the trauma that's often associated with family legal problems. A whimsical mural with flying cars and cookies greets you. Artwork created by children covers the hallways as families approach what can be an intimidating, stark courtroom. For youngsters needing to be shielded from their parents' battles, a fun-filled daycare center is on site, as well as a supervised visitation center for parents with high conflict or domestic abuse situations. Here, a multitude of services for the family's non-legal issues are offered, from addictions counseling to anger management to co-parenting classes. This is what advocates call therapeutic jurisprudence.
It's a court system that addresses the family holistically, and it can resolve all of the family's legal needs: divorce, custody, child support, domestic violence. But it can also and should also address the non-legal needs that are often in family law cases much more significant than the legal issues. For example, substance abuse, mental health issues, family violence.
Judges say the idea behind unified family courts is that they're a one-stop shop for a family's legal and non-legal issues.
What you're really trying to do is solve a problem. And that's, in a nutshell, that's what you're doing. You're trying to solve the family's problem. You can't do that if all you're doing is putting a bandage here, a bandage there, and you never see the whole picture.
Family law attorneys say under unified family courts, the system is much more streamlined. The vast majority of divorce cases never goes to trial. More importantly, unified family courts do a much better job addressing the needs of children caught in the crossfire of relationships gone bad, those who have been abused, neglected, or have juvenile delinquency issues.
Before they had a unified family court, the system was not organized. People were sent to different places, and there was a lot of confusion. Right now, as an attorney, I see that the services that they render and how they handle the family is much more effective.
Research also shows that judges who work in unified family courts have much greater satisfaction rates, truly believing they are helping families at a most difficult time.
A lot of us who have worked in the unified family court system and who are advocates of it really refer to it as roll up your sleeves justice, where judges and masters get actively involved with the litigants before them to assess as best they can what are the real life problems that these particular litigants have had that have caused them to have legal issues to be brought before the court.
The judge has the ability to see what the real problems are. The judge can deal with it effectively. And that brings some satisfaction to the judge, because the judge wants to do the very best job that he or she can do.
Since the ABA held its first conference on unified family courts in 1998, some states, such as California and Indiana, have established pilot UFCs statewide. That same year, University of Baltimore School of Law professor Barbara Babb published her research on unified family courts nationwide and has since updated her findings twice, charting their growth.
The results are pretty dramatic. From 1998 until my most recent survey, there's really been probably a 33% increase in the numbers of jurisdictions that are trying some form of unified family court, either statewide or in a selected area of the state or as a pilot project. And many of those jurisdictions that were pilot projects in 1998 have fully implemented unified family courts today. So for me, just seeing that kind of change over a relatively short period of time when dealing with such a complex institution as the justice system is really quite remarkable.
But advocates know there is much more work to be done. Still, every day in this country, thousands of families, rich and poor, face a variety of social, legal, and emotional issues involving divorce, custody, substance abuse, and domestic violence. Bouncing these families from judge to judge, courtroom to courtroom, only exacerbates their problems. Advocates say unified family courts are a more effective, therapeutic, and holistic way to treat these families.
I have realized that through my almost 30 years of practice that people just want an opportunity to be heard and to be understood. And with this unified family court, they understand the whole process and they have the services to help people, so they really don't need litigation.
The unified family court approach of connecting one family with the same team of court personnel each time the family comes to court, with the same judge to hear that family's case from start to finish, should be adopted in more jurisdictions, advocates say, for the good of the entire family, especially the innocent children.
So what we think we're doing is we are giving families, parents, tools to better determine how they can coexist, albeit not as a nuclear family.
For Candy McCall, it's now time for her new family to heal. Judith Hamilton's frustrating experience led her to become a family law attorney and a supporter of unified family courts. Advocates say it's no longer okay for America's legal professionals to say we did the best that we could. For the sake of millions of families embroiled in emotionally draining, time-consuming, and expensive legal issues, It is time to do better.
All right, so that was just a bit of an overview. We'll now get into sort of the nuts and bolts of what the Unified Family Court is. Just a sense of family law litigants. One of the things that we realized in Maryland when we started this work was that there really was no sense about how prolific family law cases were. Nobody really spent the time to analyze the numbers. And now in our trial court in Maryland, family law cases occupy 43% of our trial court caseload. They exceed the number of criminal cases. And this is in New Jersey, the number is 35%. In Nevada, the number is 58%. I did a look at, took a look at your court statistics at the end of FY17. Your district court handles 55% family law cases more than criminal cases. In Douglas County, the number is about 56% in your district court. We talked a little bit about what America's families are looking like these days. There's still a very high divorce rate. There is also an increase in unmarried cohabitating parents. There's an increase in mental health and substance use issues, homelessness, poverty. So it's important to look at who the families are who are coming into court and need the court's services. I will also mention here that in Baltimore City, in 89% of our family law cases, both sides are unrepresented. So we have a very significant self-represented litigation issue in Baltimore City. 89%, both sides unrepresented. The volume and scope of family law cases are often complicated by non-legal issues. You heard some of that mentioned in the DVD. So that in reality, the court remains, I have a colleague who writes often about family courts also, who says families don't go to court for help, and indeed I take issue with that. They do come to court for help. And if they're not coming to court for help, court is the last place where they often can get help. So I think that it's important to keep that in mind as well. We've done a number of studies over the years trying to document problems with existing family justice systems. We've done some with the ABA, some on our own. Some of these have been compiled by administrative offices of courts in various areas. So this is just a summary. Court systems are overwhelmed with cases and self-represented litigants. The process is time-consuming, expensive, cumbersome, and duplicative often. Child-related issues do not receive proper attention, and we also found that there's a need for judges really to have background training, specialized training in children's issues. There is inadequate resort to alternative dispute resolution, something mentioned earlier. There is inadequate coordination of litigation involving the same family. And as I go down this list, I don't know if any of these are problems that you personally have encountered in your practice. Obviously not, there isn't one jurisdiction that has all of these issues, but these are some of the problems that families face. There is a lack of interest, temperament, and understanding by some judges hearing family law cases. I myself have been on the receiving end of that, where judges have said, I don't really want to hear this case. Can you go out in the hall and try to work it out? And if your client is standing there with you, that's not a very good message for the client, or if you happen to be supervising a law student at the time, for a law student to hear. Now, again, today we have seen very dedicated judges, so not speaking about the current, the population in this room, but there are some judges who really don't want to hear family law cases, and they make it very clear. Judges are often deciding psychosocial matters without proper training. We are big believers in judicial education, either before, during, or during the time that you are on the bench, or preferably both. There is a lack of attention to the needs of poor and unrepresented litigants, and there is insufficient coordination among various professionals working with families and children. Sometimes they can become overwhelmed with the numbers of professionals who are involved with their cases. So why do we continue to work at improving the family justice system? I did that survey yet again. Each time I do it, I say I'm not going to do this anymore, but I still do it because I want to know what's happening in the country, who's doing what, how are different states handling family law matters. There are still about 13 states that have no way of differentiating family law cases from any other type of case. A judge might hear a criminal case, then they may hear a tort case, and then a family law case may pop up. No specialized services, nothing to differentiate a family law case. So there still is work for us to do. So just briefly, we'll describe what a unified family court is and then delve into some of these issues or these aspects a little more in depth. It generally is a single court system with comprehensive subject matter jurisdiction, and by that we advocate that juvenile and delinquency and dependency matters be considered as part of the comprehensive subject matter jurisdiction, because often families are involved in many of these kinds of cases. We often have children who cross over from dependency into delinquency. We have parents involved with those children who may be getting a divorce. All of this really needs to be looked at as a whole. It's a court that addresses legal, social, and emotional issues with holistic treatment, as I just mentioned. It's a court that utilizes informal court processes, social services, and resources. It aims for a comprehensive resolution, and it is tailored to the individual family's legal, personal, emotional, and social needs. So each family deserves its own attention. It's a court that operates by the one family, one judge model, or the one case, one judge model, or the one family, one team model, and I'll explain these in a minute. And it's a court that operates with efficiency and compassion. And I want to read a quote. A lot of the reading that we've been doing some reading about your 0 to 3 court that Judge Johnson helped spearhead. And in one of his articles, he said, and I'm quoting, "The judge must set a therapeutic tone. The judge must be an empathetic listener and leader. A judge must insist that the team and providers be trained to treat and value each family as one's own. Remarkable improvement occurs when parents know and feel that they and their children matter. Respect, dignity, patience, encouragement, affirmation with accountability, and compassion help heal the parents and children. They come to us in trauma. We should not and must not add to that trauma." So I think that's a wonderful quote about how a court needs to operate with efficiency and compassion. Just a little bit about the history of unified family courts, very short bit. In 1914, Cincinnati created the first unified family court, and that followed the first juvenile court that was created in Chicago in 1899. In 1959, there was something called the National Family Court Act. There was a push in 1959 to really get this notion out and to educate people about what a unified family court was and to advocate. Some states adopted quickly after that. In 1961, Rhode Island created the first unified family court. In 1962, New York followed. In 1965, Hawaii created its family court, and there's still some of the really good models of a unified family court. As you saw in the DVD, the ABA, the American Bar Association, has promoted unified family courts since 1994, and they have convened 2 summits, 1998 and 2007. So we'll talk now about a blueprint to establish a unified family court. Let's look first at court structure. The court structure can vary. It can be a specialized, separate, independent court And the two states that mirror that or that adopt that approach, Rhode Island and Delaware, they have a separate family court. It can be a division or a department of an existing court. This is what we've done in Maryland. We've created a family division within our trial court of general jurisdiction. Hawaii also operates this way. New Jersey operates this way. So there's a family division created within the court itself. And it's a court that's staffed with specialized judges. We advocate, as I said, comprehensive subject matter jurisdiction, including juvenile delinquency and child welfare. And I know there could be pushback about that. It's certainly a topic of discussion, but we at CFCC actually did a study on this issue, and I'll let Gloria talk for a few minutes about the results of our study.
Thank you, Barbara. Well, just by way of background very quickly, as you know now, Baltimore City does have a family division, but, and this has been a source of great concern, I know, on the part of Barbara and on me as well, that the juvenile court in Baltimore City pretty much operates as a separate court and has always operated as a separate court. So we got a grant to look at 5 jurisdictions that do incorporate delinquency or criminal family offenses into their subject matter jurisdiction. Those jurisdictions were Delaware, New Jersey, Rhode Island, Hawaii, and Porter County, Indiana. The report looks at the structure to handle delinquency matters in each state's unified family court system and makes a number of recommendations based on our research and quite extensive surveys of judges and court staff in each of the jurisdictions. The survey asked questions about use of judicial and court resources, types of services provided, diversion programs, and case management practices, among others. And we came up with some very interesting findings, I think. So here are just a few. While survey respondents had adopted different unified family court models, they were unanimous in their agreement that the incorporation of delinquency into the family court subject matter jurisdiction offers significant advantages to the system as a whole. 5 of the 6 jurisdictions surveyed enjoyed a dramatically lower rate of violent juvenile crime than is found in Maryland. Now, I would not be so bold as to suggest that was the only reason that Baltimore City had a much higher rate of juvenile crime, but just saying, this is what we found. There was also a significantly higher rate of arrests for drug violations among juveniles in Maryland than in any of the other 5 jurisdictions. Surveys indicated that treatment is ordered in the vast majority of juvenile matters and that courts did assist in connecting the juvenile to services. All of the courts had regularly scheduled judicial review calendars to monitor treatment progress in cases where substance abuse and/or mental health treatment was ordered. The number of programs made available by family courts to families and children are enhanced and increased by the broad subject matter jurisdiction of the Unified Family Court. The Unified Family Court provides a wider array of services catering to the needs of families and children in crisis than is typically possible in a standalone court. So, for example, the pilot Unified Family Courts in Indiana offered employment programs, tutoring, mentoring, counseling, and community service opportunities to delinquents. In New Jersey, delinquents and their families have available to them services such as emergency housing, medical services, survivor support groups, elder assistance, anger management classes or counseling, and public assistance, among others. In 4 of the 6 sites surveyed, the family court has a unit or process that is managed directly by the court with court employees who assist with intake and coordination of all or part of the delinquency caseload. In addition, each site used some type of automated information system to coordinate and retrieve information on family-related cases and families involved in the court system. 5 of the surveyed courts allowed outside agencies under certain circumstances to have access to their information systems. And finally, case management practices took many forms in each of the jurisdictions, ranging from those done manually to those that depend on sophisticated computer systems. So on one end of the spectrum, Porter County had a pilot project that designed regularly updated worksheets as part of their case management reporting. These worksheets contain family information and family court involvement for each individual going through the family court system. On the other end of the spectrum, there were a number of surveyed courts who did have automated information systems providing information about juveniles and families and facilitating the exchange of information within the court and with outside agencies. So, bottom line, we thought that we found a very persuasive case in the survey to support incorporating delinquency in the Unified Family Court, but we're still waiting for Baltimore to adopt it. Thank you.
Hold up, the report is
Oh.
available, so I don't know if you brought a copy.
I have,
Okay.
here's a copy. I think it might be downloadable as well.
Yeah, so it's called A Strong Presence in the Life of the Child. We have a number of publications that you can get from various links, and that's, if you're interested in this publication, that's the name of it.
Thank you, Gloria. So, one of the most important aspects of a unified family court is some type of specialized case management or case processing system. So it's heavy on administrative personnel. And what is necessary is some type of early and hands-on case processing. It's similar again to the 0 to 3 court, or some of the ways that you operate now where you have pre-conferences. Yes. So that type of involvement with the family very early in the process. And there's an opportunity there to link the family with needed services. Case management is an ongoing process. I can tell you one of the ways that we do it in Maryland is that we have magistrates who are similar to, I think you have referees or judicial personnel. I'm sorry?
You have child support referees?
Child support referees. In our system, magistrates they're not judges, but they're judicially appointed, and they meet with each of the litigants in a case immediately upon issue being joined, and they try to work out at that point early on whether there are any issues that can be resolved. If there are custody issues, we have a statute that requires mandatory mediation of custody cases, so those cases are sent to mediation. In other words, you sort of get the groundwork. What does this family need? If there are substance use issues that are present from the get-go, we try to link the families with substance use services. If there are mental health issues, they get a link to those kinds of services immediately. So it's an opportunity early on to basically see what it is this family needs from the court and try to deliver as early as possible. There are deadlines set for discovery, for a pretrial conference, for any temporary hearings that may be necessary in the case, temporary child support, temporary custody, temporary alimony, so that the families know from the beginning of the process what the process is going to look like and when they will be expected to do certain things. And we have found that system works pretty well. All right, there are different ways, different models for conducting the management of a case and of a family in the court. The model that we have adopted in Maryland is one judge, one case, where we are asking just that the judge, not just because sometimes these cases go on for a long time, but that a case stay with a judge from start to finish. That is in opposition to, or in contrast to, the one judge, one family model, where every time a family comes to court, they appear before the same judge. I know that you have that model in some of your dependency cases, and also delinquency and dependency, and that may work very well for you. We decided in Maryland not to use that model because, and we were persuaded by a wonderful judge, he went on to become the executive director of the National Council of Juvenile and Family Court Judges, David Mitchell. I don't know if you know David Mitchell. He sat on the juvenile bench for 20 years, and he said, I got to know, as much as I didn't want to feel biased, I got to know second and third generations of families, and I sort of almost knew too much about them when the family appeared before me. So that was persuasive for us that perhaps a judge might have too much information. There's also the possibility that As an attorney, if you're appearing before a judge with whom you may not get along, you might want an option to appear before another judge. So there are pros and cons, and I think that's something that really demands a lot of input from stakeholders, a lot of discussion about which approach you want to adopt. We were thankful just to get the one judge, one case approach, because in the years I was practicing in Maryland, before there was a family division, I could appear before 4 or 5 different judges before the case was over. Judges would be on the family court rotation or the family law rotation for 6 months at a time. So I would go in for one appearance and be before one judge. A few months later, I'd be before another judge because they're rotating off. So we at least got to the point where we are at the one judge, one case model. And the other approach that has been tried successfully and implemented successfully in many jurisdictions is one team, one family, where every time the family comes to court, there's an administrative team. It might be a case manager who knows that family and can address the family's needs or direct the family to perhaps the settlement, the conference with the magistrate, some way to really know something about that family but not have the potential necessarily for bias that might exist if the family appear before the same judge. So that's another model that some states are experimenting with today, the one team, one family approach. We feel that this type of case management system, whichever you adopt, really gives a greater sense of responsibility to the families. It allows the court to fashion more effective legal outcomes. It does require a high degree of court administration and organization, but the resources expended in that area, I think, are well worth it because it oftentimes prevents the families from returning to court, repeat court appearances, so we feel that the resources, that's a good use of resources. Family court is also a court that supplies services, and these can either be supplied by the court or connected from the court to the community. We have a combination of both in Maryland. By the rule that created our family division establishes that there must be certain mandated services, substance use services, custody evaluation. There are 6 of them and they're escaping me right now. But in every one of our family divisions, our rule also creates a position called the Family Services Coordinator. And that person's job is to assess the services that exist outside the court in the jurisdiction, to know what those services are so that when the court needs to order services, it can connect the families to the services as they exist in the community. Our family court is structured only in the largest population areas in the state, so we have 5 family courts. The Family Support Services Coordinator operates in every jurisdiction, whether there's a family court or not. So appropriate even in rural jurisdictions, the court needs to know what is out in the community that can assist the families and children who need those services. So that's been a great benefit in our system. You do need to determine what services are essential for your client population. I am sorry to say Baltimore City remains the heroin capital of the United States. So we have a tremendous substance use problem. And a lot of our resources are dedicated to substance use services. But you know your population. If you don't, survey, determine what they need, what are the most important services that your jurisdiction needs, and then determine whether that's something your court can offer or you want to connect to existing services. One of the wonderful sort of benefits of this, that it does foster community involvement with the court. We talk about it as the court-community connection. It encourages or aids in public trust and confidence in the justice system when families and children know that the court is there to help them. And of course, we aim for the earliest possible delivery of the service, which is why, as I said, our magistrates try to determine the service needs almost immediately when the family comes to court. We also aim for a user-friendly court. Someone talked about making it simple for the clients, that is accessible to all litigants. We created form pleadings because we do have such a large self-represented population. We have an office in the court in every one of our in every one of our circuit courts throughout the state of Maryland that assists clients in family law cases, helps them determine the proper pleadings, the proper forms to file. Again, it's the fuzzy line between legal information, legal advice. They are providing legal information to the clients, but it's a way of assisting them so that they can at least get into court to get the help that they need. Accommodating litigants in the most helpful way possible. I think one of the things that comes to mind here is not requiring hearings when there's not a need for a hearing. And not making people come back to court if there really is no need to do that. And that's one of the things that we've been really trying to address, that have a hearing only when you really need a hearing. So those are the elements. And I would say, and I think this is one of the philosophical underpinnings of our center, and we'll talk about it in a minute, but consideration of court structure is not sufficient by itself. Society has a duty to determine how the court should intervene, and this was profoundly stated by a colleague of Judge Johnson's, Judge Michael Town, who is now a retired family court judge from the state of Hawaii, who says, "How deeply into the domestic realm can or should government go when it intervenes in the lives of families and children? Conversely, what is government's duty to families and children who are in legal and social distress?" These political and philosophical questions still bedevil public officials in America today. Yet, when society chooses to intervene, which is what we are doing as courts, it must be done well and there must be accountability. So that is part of our belief, that it must be done well. There is a duty to intervene, but we have to do it well, and we have to be accountable for what we do. So, I propose the adoption of an interdisciplinary perspective to guide both court structure and function. And it's interdisciplinary because it's composed of two elements, something called therapeutic jurisprudence from the law, and from the social sciences, something called the ecology of human development. And I'll take you through what each of these aspects is. And these are two guiding principles for all of the work that we do at our center, the Center for Families, Children, and the Courts. We teach law students about these theories. We encourage them to practice law from this practice family law from this interdisciplinary perspective. And it's actually can practice all aspects of law from this perspective. So, what is it? Well, my thesis is that the family law process ought to aim to improve the participants' underlying behavior or situations and maximize the positive outcomes from their involvement with the court system. And I implicitly always practice law that way. Like when I do something for my client, I want the best outcome I can possibly get, something that actually helps my client. When I became a law professor, I had to start writing scholarly pieces, and I bumped into this notion of therapeutic jurisprudence. And that essentially is what TJ, as we call it, says. And for me, it made the implicit explicit. I found this notion. It was developed in the late 1980s by two mental health professors teaching mental health law, Professor David Wexler and the late Professor Bruce Winnick. We've collaborated with them on many projects. And they came up with this name called therapeutic jurisprudence. And it basically studies the role of law as a therapeutic agent. It says the law is a social force that can produce therapeutic or positive outcomes or anti-therapeutic or negative consequences. And so I bumped into this notion. I was the first scholar to apply it to family law. It's now applied to every area of the law. It is practiced extensively internationally. In a minute, I'll give you the website to the International Network on Therapeutic Jurisprudence. There is even a prison in Australia, which is run by a female. She is the warden of the prison, and she has restructured the entire prison in her jurisdiction along TJ principles. So, these therapeutic consequences, these positive or negative consequences, can flow from the substantive law itself and the rules of court. In other words, you could have a statute that really is having a pretty negative effect on the families and children it is supposed to be serving. You could have rules that have the same outcome. You could have statutes that have very positive impacts for families and children, same with rules. And it also stems from the behavior of legal actors. And by this we mean everybody in the court system, from the moment you walk through the security to the minute you appear before the judge. One of the things we were very impressed by this morning was how really friendly the people were who were checking us through security. And that, it may seem insignificant or not even noteworthy to you, but imagine yourself a family law attorney or a family law litigant, or any litigant for that matter. You're stepping into the courthouse, you're already stressed, and you bump into somebody who's not necessarily as friendly as your security personnel were this morning to us, and as we saw to everybody who came through. So it's really looking at everybody's behavior. The behavior not only of attorneys and judges, but everybody who has some contact with the litigants, and trying to make sure that they have a positive outcome from their court experience. Judge Johnson, again quoting him, because his reading is the reading that I've done most, in one of his articles he was talking about his 0 to 3 family drug treatment court. He said, "The court is dedicated to improving the lives of children and their parents. Isn't that what each of our family courts should be doing? Making children's and families' lives better as a result of their involvement with us and the justice system. They're coming for help. We need to help them." So the task is to identify and examine empirically. We don't all have the time to conduct empirical research, but to look at the relationships between legal arrangements, whether it's a rule, a statute, behavior, and therapeutic outcomes. How can we change things to make it better for the parents and children? TJ is individualized. It's determined, the therapeutic outcome is determined by the individual's own viewpoint, which the courts should identify, assess, and attempt to honor. And we're not talking about the court imposing its own viewpoint, which some critics of TJ suggest. On the other hand, TJ does not trump other considerations. These are still courts. Due process, the rule of law still applies. Community safety is still a value we all adhere to. So it is basically a lens to shed light on the therapeutic impact of the law. So it's just one way of looking at what we're doing. Are we having positive consequences, therapeutic consequences, or are we having negative consequences? Is there something we can change, something we can do better? There's the website of the there's now an international society on therapeutic jurisprudence. So, I urge you just to take a look at some of the reading, see if any of it appeals to you. It's really quite fascinating. And as I said, it is an international body of judges, attorneys, court personnel, prison officials, etc. So, what are some consequences of adopting a therapeutic approach? Well, you empower individuals by allowing them to learn self-determining behavior. If they have a greater say in the outcome of their case, they learn self-determining behavior. What is the consequence of that? They're not going to keep coming back to court. They're going to learn, hopefully, to resolve some of their issues by themselves through their own behavior. It's also a way to empower judges by allowing judges to be creative and to consider alternatives. So it's really an empowering concept from a judicial standpoint. One of our good friends, Judge Peggy Hora, was the first person to write about TJ as the theory underlying drug treatment courts. They were really the first therapeutic court. They started in Miami in 1989. There are now thousands of various kinds of problem-solving courts. Your 0 to 3 court is an example, both within the United States and internationally. TJ is really the theory that underlies all of those problem-solving courts. It is also a way to protect families and children from present and future harms. It's a way to decrease emotional turmoil, promote family harmony or preservation. As I said, we encourage a therapeutic role for all court personnel, anybody involved in families coming to court. And it's a way to provide individualized and efficient, effective justice based upon parties' needs, not as opposed to their legal rights, but in relation to their legal rights. What does the law enable them to have? What do they need? How can we reconcile the two? And this is something that's known as an ethic of care. How can we reconcile needs and rights and demonstrate caring to families and children? How then does the notion of therapeutic jurisprudence contribute to court reform and family law? According to Professors Wexler and Winnick, TJ is merely a lens designed to shed light on interesting and important empirical and normative issues relating to the therapeutic impact of the law. The therapeutic jurisprudence perspective sets the stage for the articulation and debate of those questions, but it does not itself provide any of the answers. Why? Because what is therapeutic for one family, what is a therapeutic outcome for one family, may not be for the next family that comes before the court. So it's really something that is quite individualized. So that is the legal part of the framework that we advocate both for court structure and court operation. The second component comes from the social sciences. It's called the ecology of human development. And I told you that I had studied with Dr. Yuri Bronfenbrenner when I was in graduate school. His name is not a household name, but I'm sure everyone has heard of Head Start, and his research started. He is the father of Head Start, so he is very committed to families and children. And his research paradigms, was sort of his last work, was to create this way of looking at families. And if you think of this as, sort of throwing a stone in the water, the concentric circles that appear, before we describe what each of the circles is, I will say that the intent of this is to create as many connections among and between these various systems as possible. And his theory is the more you do that, the more connections you can make for families and children between and among these systems, the stronger will be their functioning. So what are the systems? Well, the one in the center is the microsystem. And these are situations in which the child has contact with influential others. Those of you who've studied sociology, human development, these are the dyadic relationships. So the parent-teacher relationships, certainly the parent-child relationship, the teacher-student relationships, the husband-wife relationship. These are the dyadic relationships that we're talking about. And these are the ones the court usually hears about. The court hears about the relationship of the child with the parents. So we've already got that one down. Most of the time we're talking about that. What we don't talk about so much are the remaining prongs of this system, the mesosystem. This is the relationship and connection between the microsystem. So sometimes we will talk about the home-school connection. How connected are the parents to a child's school? The home religious organization perspective. So a way for us to examine what's happening with the home and other systems that are affecting a child's life. The exosystem. These are settings in which a child doesn't participate, but in which significant decisions are made affecting the child and adults. For example, the parent's place of employment. Does a parent get time off to take care of a sick child? Does a parent get time off to attend child functions at the school? What's the relationship of exosystem factors to the child, the parent-child relationship? And finally, the macro system. These are the blueprints for defining and organizing the institutional life of society. For example, we all want to decrease criminal behavior. We all want to hopefully eradicate substance use disorders. These are sort of the blueprints by which we live. So I offer this social science model as a guide to assist family law attorneys, judges, services providers, and others to consider and then account for the competing influences on families and children's lives. Maybe you don't need this guide, maybe you're already doing that, but if not, it's a way for you to focus on how can you identify each of these system factors, and thereafter, how can we strengthen the connections among and between those factors for this particular family. So, having described the blueprint and the interdisciplinary framework, let's take a closer look at unified family courts. What are some of the advantages from our perspective as we have worked with court reform in various states around the country? Number one, the court has the authority to resolve all family legal matters. You can basically give this family one-stop shopping. You can resolve all of their issues. You can coordinate their issues. You can resolve them in a more timely fashion. If you have the ability to hear and decide these issues, you're going to be giving the families more timely resolution. You can reduce or eliminate conflicting or redundant orders, which often happens when different judges are hearing different parts of the same case. You can reduce litigation. An early intervention or hands-on approach, as I mentioned, with the case conferencing. These are preventive measures for the families, can keep things from getting worse. Less adversarial dispute resolution. We adopt a problem-solving approach. Connections for families to services. More positive outcomes, we hope, and results for families. The judiciary being more informed about families and children's lives and therefore able to make more responsive decisions. Increased judicial satisfaction. Diane's colleagues, Dr. Deborah Chase, and Judge Peggy Hora, whom I mentioned earlier, actually did a study about this and found that judicial satisfaction is higher for judges sitting in unified family courts than for judges sitting in just a general non-unified court hearing family law matters. So there is empirical evidence that judicial satisfaction is greater. There is an emphasis on interdisciplinary training for judges. There are lots of wonderful training programs offered by the National Council, by the Judicial College, many opportunities for training. Our judges in Maryland participate in something called ASTAR or ASTAR. Is that how you pronounce it, ASTAR? I don't know if your judges participate in that, which is science-based training. We're now learning the effects of trauma on the developing brain, so this gives some scientific training to our judges. A unified family court also fosters increased court community connection and increased public trust and confidence in the justice system. I keep saying every time I teach my classes, I say I want to live long enough to not hear a bad lawyer joke. Because lawyers are good. We do good work, we help people, and I just don't want to hear any. I want to wipe bad lawyer jokes off the stage. What are some concerns? And there are concerns. We're not hiding anything here. Some argue that there is decreased confidentiality because the court has more access to family information. And California, Diane, you can speak to this, has addressed it by alerting families to any of the information sharing that's taking place between perhaps one issue and another, and allowing the litigants to have an opportunity to have a hearing about those issues. You might want to speak more about that later. Judges' reluctance to hear family law matters and the opportunity for burnout. In Delaware, in Rhode Island, judges who sit in the family court sit for life. So there are people who like to do this work and are suited to do it day in, day out for long periods of time, and who want to do it for long periods of time. your juvenile court judges are doing this work day in, day out. And those of you who practice in this area, probably a lot of your practice is focused on family law. So I think burnout can be overrated. On the other hand, I understand that these cases are emotionally taxing, and there are ways to try to address that. You can rotate among different dockets. There is a perception that assignment to a unified family court or any type of family court is not as prestigious as hearing other case types. Our friend Catherine Ross, who did one of the early studies for the American Bar Association, she teaches at George Washington Law School, calls family courts the stepchildren of the justice system, that they really are relegated often to the lowest level of court. We believe that family courts should be at the level of the trial court of general jurisdiction. Judges' unwillingness to function as problem solvers and the perception of acting like a social worker. Potential bias of the judge due to increased information and family contact. The fact that it does require, a unified family court does require considerable administrative resources, and it requires time to train court personnel and implement. There are funding issues. You heard Gloria talk about the need for effective data and case management systems, and it may require legislation or court rule. We implemented our family court in Maryland by court rule after 10 years of unsuccessful advocacy before the legislature. So it may require something to change the structure of your court system. I don't think that's insurmountable, but it's certainly something to consider. So the court reform process, we talk about it in terms of the 3 C's: coordination, collaboration, and creativity. One of our colleagues says that you need a what-if team. What if we did this? And a how-to team. The what-if team comes up with some great ideas, and the how-to team can be the same members. Says, okay, this is how we're going to do it. And you are all stakeholders in this process. Gloria is one of her favorite words, stakeholder, change agents. All of these, or as many of these stakeholders, should be involved in your process as possible. I won't read off the list, but you can see it's extensive. And the more input you can get about how your family justice system should be structured, the more satisfactory it will be for the users of the system, whether you're an attorney, a judge, court personnel, or a litigant in the system. So that's the end of the slideshow. Questions for any of us at this point? I'm not the only person here. Yes?
You touched on this just briefly in regards to due process, but I guess my concern lies in how does the court function when it is adversarial? Or whether it's in a divorce, or whether it's in a delinquency or a neglect case, there is time. How is it preserving the due process of the person who there's allegations against? If it's, for instance, the child in the delinquency.
Yeah, these are courts. So nobody is saying, I mean, I'm not someone who says, let's make everything, let's throw out everything that we know about courts and the operation of lawyers. I think that, we as lawyers can do something that other members of the population can't do. We can appear before a judge and can advocate for our clients. And advocacy is very important. It doesn't necessarily always have to be adversarial. And so I think that's the difference, that advocacy doesn't mean necessarily being adversarial, controversial. Diane, you look like you have something to say.
Yeah, I want to add to that because that's been a real issue that's been addressed in the problem-solving court arena. And so in California, I can speak to because it was under our center, delinquency mental health courts, delinquency drug courts, so I'm talking specifically of juvenile justice court. And there was a lot of controversy over that because generally the rule is that you have to take a plea first and then we'll work through how we're going to address the issues. And they came up with we kind of take a plea, which if things go south, we can withdraw the plea, which brought in a lot of the public defenders. But I used to sit in courts and observe, and I would see over and over and over again where the child youth attorney would say, they would let them plea or admit to a relapse in the context of the drug court because they knew that was going to be acknowledged. There may be some type of accountability, but we were going to move on. So that it was a long therapeutic process. It wasn't going to be, okay, you get busted, you end up back in juvenile detention and we're just going to throw up our hands. That everybody was part of this process. There still was the role, the attorney still monitored carefully to make certain that there was due process, but there was also an acknowledgement that it was part of this problem, that everybody was working together. They all had their individual roles, but everybody was still working together to hopefully end up with a successful outcome. Does that answer your question a little bit? I mean, nobody throws it out. I haven't observed a single court system that says, okay, we're just going to forget about due process, we're going to forget about the law, and just go out there to save. It's how do we do it within the confines of the law? How do we work together trying to make sure that we get successful outcomes?
And along with problem-solving courts, I think the other way to address this is to try as much as possible to make effective use of mediation. We're doing a lot of mediation in child welfare cases. And so, to try to remove, at least from the start, some of the adversarialness in this situation. Now, I know it's not always possible, but to the extent possible, do what we can to, and always focus on what can be a positive outcome. Even when you need to take a case all the way to trial and have the judge make the findings, what can be the most effective outcome for your client in that situation?
I have a question about services. And in Nebraska, for example, most of our services, be they therapeutic for drugs, just getting a simple psychiatric or psychological evaluation, are Lincoln East. When you get past Lincoln, the farther you get out to western Nebraska, it's like a whole different world. They don't have placements in the same amount. They don't have virtually any sorts of services. There are situations where there's just such disparity in the court, in the state, from the standpoint of where services are located. And then secondary, who pays for all this stuff?
Two very good questions, and I can just speak about what happened in Maryland. Our legislature was so interested in, we were a grassroots effort. We started from the ground up and said, we need to change this. At first, there was not a lot of judicial leadership. Our former chief judge, the one before, Chief Judge Bell, was opposed to any form of unified family court. So we were really facing an uphill battle, and we did for 10 years. We testified, many people testified. And the legislature was pretty much in favor of it, but deferred to the chief judge. Finally, after 10 years, and hopefully it wouldn't take that long anywhere else, the legislature committed resources in advance to the court system if they would change things. They heard enough stories about the failings of the system from client litigants who had experiences with the court and were testifying before the legislature. They allocated funding for services, for the creation of the family division. And we have rural areas in the state of Maryland as well where there were not services being offered. So that funding enabled them to create some of those services. So getting the legislature on board to understand the need for services. I think part of what people don't understand is that in family law cases, the non-legal needs, the things they need services for, are as important, if not more important, than some of the legal issues often. They drive the legal issues. So you can't really address effectively the legal issues unless and until you have those services. And that's a matter of, I think, educating the people who control your funding. Go ahead, Gloria.
Just to piggyback on what you said, Barbara, and one of the hallmarks of the initiative at the American Bar Association was that the pilot projects really used this opportunity to create a community-wide advocacy effort. So in addition to all the expected partners and stakeholders, the attorneys, judges, court staff, they brought in, for example, the local chapters of the American Medical Association, the Chamber of Commerce, so that it was a community-wide perspective and a community-wide emphasis on many of these public health issues that you talk about, which in turn leads to a greater public interest and public focus on the kinds of problems you talk about in your more rural or less urban areas.
Yeah, I just wanted, so California is a big state, and it always surprises me when I realize that 30 of the 58 counties in California have 2 judges. Now, in order to qualify for only having 2 judges in California, that means you have to be exceedingly small. So we have 2 counties, Alpine, I can't remember the other one, that actually they no longer have banks, they don't have ATM machines. That's how small their populations are. And so we have a lot of the same issues that pop up. What is happening when they don't get services is trying to have regional approaches so that even though sometimes there are very large distances to travel, counties will pair up. Increasingly in the areas of substance abuse and mental health, it's not optimal, but they're providing services via Skype, or so they're having sessions via Skype or some internet type of thing. So they're trying all different ways to get them services. And some of the cases, judges are not doing the trial, but any, post-dispo or review hearings, checking in on visitation schedules, those kinds of things, just checking in to say, how are you doing in treatment? They're doing via, some type of FaceTime or Skype, those kinds of things to address some of those issues.
Well, the way I envision it is there's a divorce file, and then there's a judge that resolves anything that can't be resolved. And then there's this big in-between where there's all these services available. Who decides what services your client gets?
And so these are all good questions. The attorney can advocate on behalf of the client for services, and you can structure your system so that someone, for example, in Maryland, a magistrate or non-judicial officers who meet with the parties early on, they talk to the parties, and if they're represented, their attorneys about what might be useful services. Sometimes there is no need for service. They don't need services, but that's a way to do it early on. Whoever makes the decision, it can be a judge. You can have an early hearing with the judge. I actually believe that judges should be preserved for the things that judges do best, and conducting trials, those kinds of making orders. But you can decide that you want to use your judges in that role as well, that the judges help determine which services clients need and order accordingly. It really depends on how you want to structure your system. Well, anybody else want to respond here to
Case managers.
Case managers,
Yeah.
right.
In Baltimore.
And attorney do case managers?
So you're managing your own case. That's right.
Oh, yes.
Which is what I said. You can advocate for the services you would like your client to have as well. Okay.
Do you find that unified family courts promote pro se litigants? Or has Baltimore always been at 89%?
Baltimore has always had problems. We have not enough, not unlike the rest of the country, not enough legal services attorneys. The greatest area of unmet legal need is in the family law area. And we did a study in 1989, and oddly enough, 89% of the family law litigants, low-income family law litigants who needed representation, did not have it. So it remains the greatest area of unmet legal need. It's always been a problem in Baltimore City. I don't think a unified family court necessarily enables that. I think what we're aiming for is that people need to have access to the justice system, because there are certain things that we need courts for and only courts can do. So we want to make the system as accessible as possible. But does it promote that? I would say not. If you ask most self-represented litigants, would they like to have an attorney? They'll tell you yes, they would. So.
And in California, from when I started practicing, and I was representing, when I was practicing in the early 80s, I never went to court, and I was representing, I had been a teacher also for a brief time, colleagues or former colleagues going through their divorces. There was always an attorney on the other side. California, it's now actually about 90% in family law. And whether the courts vary from county to county, from jurisdiction to jurisdiction, as far as whether they have a unified family court or not. And there's no difference. We've looked at that. So, no, I think that's just a whole other area unto itself.
Let me just say, along this line, there is a movement afoot to remove a lot of things from the court system. And you can determine for yourselves whether you think that's a good or bad idea. There's a lot of, some things ought to be able to be done administratively. There's a movement to remove in some jurisdictions custody or have shortened custody trials. So there are things popping up around the country that are attempts to try to resolve some of the self-represented litigant issues. I, for one, will continue to advocate for the betterment of courts, because courts hopefully are here to stay. I mean, it's the one place where everybody supposedly is equal, and we want courts to stick around. So I'm going to continue to utilize my time to try to improve the court system. So, yeah.
My name is Judge Harmon, and I am here because I have kind of a unique perspective. I am one of the few judges that does not have juvenile court jurisdiction, but what I have is jurisdiction in guardianships, conservatorships. We have concurrent jurisdiction with the divorce courts, and we have protection orders. And I've heard you talk this afternoon about delinquency, dependency. I haven't heard you talk about guardianship. And I will tell you, in my court, 90% of the guardianship work that I see, it has nothing to do with any public entity coming in and filing a guardianship. It's grandparents, and it's kids, and it's children fighting that guardianship. And the issue I have, I'd love to have resources as a trial court judge in a guardianship, but I do not have those. So I am curious as to how guardianships would be incorporated into the one court system. Because as a probate judge in Nebraska, I have that jurisdiction, but I certainly don't have the tools available that a juvenile court judge does.
And again, I didn't go through all of the things that would be included in comprehensive subject matter jurisdiction, but guardianship would be one of them. You would be part of the Unified Family Court. So.
Yes, and I raised that with Barbara when we were reviewing all the materials. I said, I don't see anything here on guardianship, and laid out exactly what you're talking about. And that has been a driving factor in some of the jurisdictions in California, where the guardianships in the old days were both parents died in an auto accident or something, and Aunt Susie came in and took the kids. That isn't today's guardianship. And so there was a driving, the judges started saying, we need to have the probate, which in California has a separate code, and it's all part of the Court of General Jurisdiction, but it's still its own unique court. And they got together with the juvenile court judges and the family court judges and said, no, we gotta stick together. We have to bring ourselves together and our resources together. So yeah, that's a very good issue.
I think maybe the difference in the questions are about is we have a statute here where if there is an abuse or neglect case filed against a parent, they're entitled to counsel. Whether that be in the public, it sounds like in some of these jurisdictions they don't have that, which is kind of part of the debate about this unified court is then how far does the free attorney extend to? Do you then pay that attorney to do their divorces and such, and where would that money come from? It sounds like in your jurisdiction there's no such statute entitled to.
There is. They yes, if they are indigent, if the parents are indigent, they are entitled to counsel. The child always is entitled to counsel, whether it's an abuse and neglect or a delinquency case. So, again, that's one of the things that you would have, one of the issues that you would have to figure out is who pays for your services when do your services begin and end.
So in Baltimore, there aren't enough attorneys that are willing to do the cases.
I'm sorry?
In Baltimore, there's not enough attorneys that are willing to do the cases.
For the 89% of the litigants who are self-represented? No. Our numbers are pretty staggering, and I think there were, I don't want to give you a quote about the number of cases. We have a huge push for representation, pro bono representation. We don't have a pro bono requirement, and maybe that would help, but I don't think that is necessarily the answer. I think there are a lot of attorneys who are really taking on these cases. A lot of our large law firms have dedicated pro bono people within the office who handle their pro bono cases. So the whole notion of self-represented litigants is complex in and of itself. So.
Or can
yes,
I add?
absolutely.
So, what we did in California, when what we call exit orders, when parents or a parent, where they're ready to terminate jurisdiction of the court over the abuse and neglect case, but they want to make certain that there's a family law. If there's already an existing family law case, they may want to modify or change custody. If there isn't one, they can use the juvenile court order to create and establish a new family law file. And there was a lot of discussion about there are no attorneys. And then everybody decided, you know what? The state should go ahead and pay, because this is state funding for attorneys in the child abuse and neglect case. The state should pay for it. Because in the long run, not only does it help the families, it gets the case out of the system. And so we don't have child welfare involved anymore. We don't have the court involved. And it was, filing the papers and having them open up the case. If down the road there are problems, things may happen where the abuser comes back into mom's home or something like that. They've developed mechanisms so that, again, if it's a unified family court, the one team approach knows about that. So they can deal with that versus it's not going off to some strange court where there's no communication. But yeah, they decided that the minimal cost for having the attorney who had been representing the parent in the dependency, the child abuse and neglect case, made sense for them. They know the family, they know everybody, they know what type of visitation schedule would be good. They should stay on the case, and the child's attorney even participates, and they often do it through a mediated process. So,
right. So you're basically still sending these people to a district court judge that reinvents the wheel, whereas the juvenile court judge has already been invested in these people's lives for years and knows all these things.
And what we're leaving out in these bridge orders is the number one thing, which is confidence. That is the most important thing to these people. Having had to sit down with a couple of people and try to explain to them originally, really, I'm still married to him.
Yeah.
He can still run debts. And these are usually women that have men that have not appeared in the juvenile court, have not done anything. The only thing that saved them from having their rights terminated was that the mother got involved. She worked. And we helped her get back on her feet and then said, but you're going to have to be married to a woman who can't help you with that. You know, so, I mean, it doesn't. There's one little piece left that we really should do.
A question about the 89%. Does your county not pay for court-appointed counsel for indigent parents?
Minimally, and it will not in just a general domestic relation case. They're not entitled to counsel. We have some money to pay for an attorney for the child. An attorney for the child is not appointed in all custody cases. You have to request it. The court can assign one on its own, but rarely does. When I practiced in New York, every child had an attorney. It was paid for by the state. The parents had attorneys. If they couldn't afford one, one was appointed and paid for by the state. So it's just a matter of how. It's not great. I'm not bragging. It's terrible. I think people should have representation, but the answer is no.
So they can, indigent parents can be represented by legal services if they pick it up or by a pro bono lawyer.
Correct.
And that's it.
Correct.
Wow.
Yes. And, hopefully with, do you have a rule or a statute on discrete task representation here? Unbundling? Yes. We just enacted that statute, and there's a lot of attorney training going on throughout the state about that. So hopefully that will motivate some attorneys to at least take a piece of a case. So.
Thanks. Yeah, I'm glad you addressed both the advantages and listed some disadvantages too. I was curious if there are any resources out there to address some of the disadvantages. And the reason I ask is I think the most important one is the transition issue. Now, how do we transition from a separate system to a unified system? And don't get me wrong, I'm not necessarily a critic. I'm also a New York practitioner. I haven't practiced there for about 20 years. I've practiced maybe 2 years in the Unified Family Court in downtown Brooklyn. And I came back here, and I do see the advantages of having the one-stop shopping and some professionals who are dedicated to that field. So I'm curious if there are any resources to address the criticism, but in particular, resources to kind of show us how we could do a transition.
Yeah, what happened in Maryland was the chief judge created an implementation committee, and it was composed of judges, court clerks at both the state and the county well, we're the only city that has one, but attorneys, so people who could really come up with a plan about how to implement this. And, actually I have to say it was pretty seamless once we created the rule. Basically, each of the 5 courts was charged with getting from point A to point B, and the implementation committee helped. So, Diane, you may have some resources that you're...
When we did it with the American Bar Association, it was really minimal cost, and that's the beauty of creating a pilot project. Because for example, Atlanta, the chief judge there just created by rule her pilot project, and they didn't need additional resources. They just strategically decided, planned out how to do it. So, and it's minimal cost.
So when I mentioned that I was talking about this, it was at a public function, and what do we do now? What's it look like from the point of those we serve, and what might it look like? And so this senator buttonholed me and said, "This is a great idea. I'm putting in a bill, and you're going to do it." And he did. Then I had the Chief Justice call me. He said, "Judson, what's going on with this bill? Unified Family Court." I'm like, I was just talking. So we reeled it back because we were just talking. It would have to be coordinated, and that's what this is about. And so it is for a pilot here. Perhaps that's what we will propose when we finish with all of this, subject to approval. But that would be the transition piece to build on what we have and enhance what we're doing so it's more seamless and so forth. So I don't think we really have to worry about that. We've got public-private interest in this and the three branches of government. So it's more like, what does our community think, and what might we be willing to pilot, and then test it and see the advantages, maybe things to tweak, and if it could be replicated elsewhere, and what does that mean for that community, because they have to shape it themselves. What does it mean for rural areas? We talked about the gap in counties, distance, driving, and the like. So that's what this committee is through the Supreme Court.
And there's one thing I can add to that. There are resources as you go along. I thought I had, I just didn't bring it with me. The Center's published performance standards and measures, so ways that you can, once it's up and running, begin to assess a family court, a family division. So there are tools available. Yes?
I may be asking the obvious here, but I think I'm a little confused because the information says that this is accessible to all litigants. Is that, are the families juvenile court involved families, or are they just anybody that needs to get a divorce is now becomes part of this unified system? Because obviously you have families that already have a substantial court involvement, and then you have some people that, other than getting a divorce, they have no other court involvement whatsoever in their life. So is the idea that it would be everybody, or just the juvenile court?
No, it's everybody. I mean, the idea. Now, look, there are some people for whom court is just sort of a minor inconvenience. They need it to get a divorce. For example, in Maryland, everybody. When I practiced in New York, I handled divorce cases. I never had a divorce hearing. It was all done by paper, affidavit, submission of appropriate paperwork. In Maryland, every person who wants a divorce has to testify before a judge, and until this year, had to have a witness corroborate all of, even if it was uncontested, had to have a witness corroborate all of the necessary allegations. Now, we've done away with the witness requirement, fortunately, but every divorce litigant has to testify before a judge. So, some people will have very minimal involvement with the court. Some will have more extensive involvement. But the idea is that the subject matter jurisdiction, which has to be conferred by rule or statute, includes all of it. Everything family related, from divorce to child dependency, juvenile delinquency. The court has the power to hear and address all of those issues.
If I understand correctly from Judge Harmon's question, it would also
Guardianship, yes. And I can run down the list of, for example, this is what we have. It was, our family division was created by court rule. Dissolution of marriage, including divorce, annulment, property distribution. Child custody and visitation, including the Uniform Child Custody Jurisdiction and Enforcement Act, the Parental Kidnapping Prevention Act. Alimony, spousal support, child support, including UIFSA. Establishment and termination of the parent-child relationship, paternity, adoption, guardianship that terminates parental rights, and emancipation. Criminal non-support and desertion, name changes, guardianship of minors and disabled individuals, involuntary admission and emergency evaluation, family legal medical issues, including decisions on the withholding or withdrawal of life-sustaining medical procedures, actions involving domestic violence, juvenile causes, or any other matters that a judge feels are appropriate to assign to the family division. So it's fairly comprehensive. The problem that Gloria alluded to in Baltimore City is at the same time we were creating family divisions, Baltimore City was well on its way and had constructed a new courthouse for juvenile cases. So we have this physical divide between the courthouse that handles everything else and the courthouse that handles juvenile dependency and delinquency cases. And it's a wonderful courthouse. It's got all of the offices that should be there, Department of Social Services, Public Defender's Office, Legal Aid, State's Attorney's Office, various services. I mean, it's a wonderful facility. But for some reason, they this courthouse and that courthouse haven't figured out how to communicate with one another. So that's been sort of the stumbling block just for Baltimore City. Yes.
Well, this is really an awesome discussion, and it folds into another similar kind of discussion with a previous questioner that we've done with AFCC, Dr. Michael Saini, talking about triaging the cases that come through. Connecticut and many other states, Colorado, other states are triaging.
Yeah.
So in some ways, you know, in my mind, as I'm hearing this in Nebraska, if we can afford a court services, family services officer who helps us triage things.
Yes.
He talks about the 5 buckets of divorce. Let's say you have the stampers that all they need are stamps on there. They have the next level up where they need to have input from lawyers and educators and mediators. And then you have the next level up all the way over to domestic abuse and high conflict. And in my mind, I'm picturing the Unified Family Court as more of a problem-solving court for the higher need families in the divorce, and whether we go that direction or not, but that seems to make sense to me.
Well, every bucket is going to need the Unified Family Court. I mean, even the ones who need the stamp, if you are a jurisdiction where you need the court to order the divorce, yes, every bucket will need that. Triaging is a form of differentiated case management where you're trying to sort out when the cases are filed, who needs the most attention. And to get those cases that need the most attention, the attention they need. Some don't need it immediately, like the ones who are addressed in bucket number 1 for the rubber stamp, but they would all be part of the court.
Yes,
You don't want to siphon off some of your family law cases. So, yes.
Are immigration matters included in Unified Family Court? And if not, how do you coordinate that?
They are not included. We do have a statute for special immigrant juvenile status, and they do need a family court order in order to give a custody order that then enables the immigration to proceed. But they're in our jurisdiction handled in federal court other than that piece of it. So I'm not an immigration expert, but I will say that the Unified Family Court doesn't handle it except for that piece.
Kennedy.
I'm sorry?
Do you have the Kennedy Amendment with protection orders? Women who are domestic violence, but here illegally under the Kennedy Amendment. Like legal aid can work with those people, even though they're not here legally because they're domestic violence.
I would suspect, but I don't know for sure.
Because it's a federal.
Yeah. Well, the one thing that I'm a little dissatisfied about is that we retained concurrent jurisdiction in protective order cases between our district court, which was our lowest level court, and the circuit court. And most people, the reason, part of it I understand, the district courts, there are more of them, they're more accessible. And so my compromise would be allow people to get the emergency protective order there, but then for the final protective order, it ought to move to the circuit court, to our family division, because they often need services, and the services are not available in the district court, but are in the circuit court. So we still don't have, a perfect system, but there is no real perfect system. And that the message that should be communicated here is that this is your chance to give your input to fashioning something that you think would work best for the state of Nebraska. And starting with Douglas County. This is where we're Yes.
I may be asking something that's obvious to everyone else as well. I'm thinking about this in practice, and our juvenile court is very heavily service-based right now. In contrast, our district court, where the divorces go, is not. And so if we're under this unified family court and a family enters strictly under a divorce docket, they've never been involved in child welfare, but as often happens in divorces, the parents start throwing stones at each other, and what may not have been obvious from the beginning, all of a sudden there's an allegation that dad's an alcoholic. So then will the services step in? Are they required? Is it going to become more like a juvenile court case then?
Well,
how does that work?
I don't think if a family needs services, maybe custody evaluation sounds like it might be in order there, then the family should get services. I don't see that as being, maybe here because the services are only in the juvenile court, it seems more like a juvenile court case, but I think generally there are services available in other types of family law cases.
Well, the parents
Right.
pay for that. That's my, I mean,
Yeah, no, yes.
And who would determine that? Because
That was
my
one-
experience
yeah.
my clients don't.
Okay, the payment issue, yeah. We had that discussion. Some of the services are on a sliding fee scale, so that they are offered free of charge to individuals who can't afford them or for minimal charge. We do have mandatory parent education. I think you probably have that as well. That's a service that's been around for a while, has gained popularity.
I was just going to say, and it's a reason that, again, some of our judges decided to go in the direction of a unified family court, because on the family law side, we've had over the past decade or more in California increasing laws around substance abuse and supervised visitation, all in the context of a family, what I always, and when Barbara uses family law, she's always including juvenile, and the way I was raised professionally, there's family law and there's juvenile law, and so I still I have to change my mindset, but in marital child custody cases, there has just been this gigantic proliferation of laws around mental health issues, substance abuse issues, to the point where judges sitting on the family law assignment were saying, what you're asking, where do they get the resources? What do we do? Aren't these really dependency-like cases? Fortunately, maybe Aunt Susie's living in the household, so we're not worried about child safety, or somebody else, grandma's taking the kids if there is something happening, but they really need services. And they found that by coming together and even just sharing knowledge, the judges, the attorneys, mediators, and others, that there was a benefit. They still might not get the services, but in some instances, having the services either at the court or near the court made it more accessible. So then they could work out something on a sliding scale, because it isn't always just the physical barrier. It's often the transportation, the extra time off from work. There are all different factors that make it challenging for people to get the services they need. So, and there's something to be said also, personally, that if they know this is a court that has broad jurisdiction, that they need to follow the judge's orders. Because you don't know what might happen. So it's a way of addressing it. Does that answer your question? No.
It's a start. I still need to talk about it in practice, how that works with a strict custody case.
So, for example, under our family division rule, these are the services that the court must provide. Mediation in custody and visitation matters, custody investigations, trained personnel to respond to emergencies, mental health evaluations and evaluations for alcohol and drug abuse, information services including procedural assistance to self-represented litigants, information regarding attorney referral services, parenting coordination services, parenting seminars, and any additional family support services for which funding is required. So each of our family divisions must provide those services, and then anything else that they feel they need to provide if they have funding for it.
So what if in a custody case, the service for a chemical dependency evaluation is offered to a parent because an allegation had been made, and that parent says no, thank you? I'm not gonna do it. Are there consequences as in?
Sure, and that's up to the judge. The judge can order that, and if there's not, it depends on the facts. Each case, of course, is fact specific,
Do
so.
you find there's more referrals than child welfare, or more children becoming wards of the state if parents don't participate?
No, I don't think that's the end result. I mean, we are trying to, like most places, keep cases out of the child welfare system and have the child have a parent, permanent parent. I remember having a case with a student attorney before a judge who was a wonderful judge and then went on to become a federal district court judge and a Fourth Circuit Court of Appeals judge. And he said to me, or he said to the attorney who was on the other side of the case, if I had to deny custody to every parent for whom there's an allegation of substance abuse, I wouldn't be granting any custody orders. I mean, that's just the reality. So you have to make a connection between that behavior and the child's best interest. So, yeah.
He went on to say that substance abuse doesn't necessarily make you a bad parent.
Correct. Yeah.
None of these other people.
Yeah. Yes.
Just real quick, is there any leeway for whether in situations where there may have been sort of like physical abuse and then there's a pending criminal proceeding, and that would be heard by the same judge? And in my mind, I'm thinking a case, a recent case where I had one incident that led to a juvenile court petition being filed, criminal action, child support action, then after the child came into custody, and then dad came in and initiated custody proceedings. So I have one client, she had 4 different cases.
Yeah. We did not include in our subject matter jurisdiction intrafamilial criminal offenses. Some courts do. I don't know what California does. Hawaii, I think, does. So in our jurisdiction, the same judge would not hear the criminal case. When I practiced in New York, their family court at the time, I don't know if things have changed, also did not have criminal jurisdiction, but the district attorney worked very closely with the attorneys in the family court proceeding and often would stay the criminal proceeding or do something that was in line with what was happening in the family court. So,
and that's almost unfortunate because oftentimes the children are listed as witnesses in more cases. So or kind of maybe we're missing an opportunity to at least eliminate some of that grief then. Because sometimes they have to testify twice.
Yeah, well that's part of it, is that you don't want your client or witnesses having to tell their stories, the same story over and over again before different people. Yes.
Sorry, just clarification on the question that was asked by Ms. Wolf. In regards to the scope of representation, so if you do have appointed counsel in the jurisdictions that you've seen, and they're representing an individual on a neglect case, and then it goes to custody or there's a divorce, does that appointed counsel then represent them in those actions?
Not unless there's a statute or something requiring them to do that. And it sounds like that's one of the things that you would need to consider. You do have a lot of appointed counsel, it seems as though, and therefore you would have to consider where that function would end. Yeah. Okay, well, it's been a great audience. We have some information sessions tomorrow with stakeholder meetings. Wednesday. Tomorrow we're going to Lincoln. So Wednesday we will have some information sessions, and we hope that you will come, and they're really conversations. We want to hear, as we did this afternoon, some issues, real issues and concerns that we can help you address, or find information that can help you address those concerns. But thank you so very much. You've been a great audience, and it's a pleasure to be here.